Welcome to The Explainer. So, have you ever actually stopped to wonder what happens if you go into business with someone and they make a completely catastrophic mistake? Like, do you lose your house, your life savings? Today, we're tackling a super high-stakes question of financial ruin and trust in business, and that is partnership liability. Because when the dust finally settles on a massive business failure or just one really rogue decision, we need to find out exactly who pays when things go horribly wrong.
Okay, let's dive right into this. Here's our roadmap for today. 1. The 3 types of partnerships. 2. The limited liability shield. 3. The universal agency principle. 4. When the shield breaks. And 5. Dealing with a rogue partner.
Section 1. The 3 types of partnerships. We kind of need to understand the structural taxonomy before we get into the messy liability exceptions.
And this brilliantly illustrates how, depending on the structure you choose, debts roll over to partners very, very differently. Look at a general partnership. It's unlimited liability. Debts roll over to the partners personally until literally every cent is paid. Yikes. Then, in a limited partnership, general partners still face that unlimited liability, but limited partners, they get a safety net that's capped at their capital contribution. And finally, in a limited liability partnership, or LLP, all partners enjoy limited liability. That's for sure the sweet spot.
All right, Section 2, the limited liability shield.
So, interestingly, under Section 6 and 7 of the LLP Act, we hit this concept of separate legal personality. And it's a profound legal mechanism. The business is basically treated as a completely distinct entity from its owners, meaning the LLP itself shoulders its own debts. Think about it this way. If you're a partner in a massive law firm and the firm incurs a huge financial debt, this shield means that you, as an individual partner, won't be held personally liable for it. Your personal bank account and your home completely untouched.
To sum up this whole principle, I absolutely love this phrase. Whatever happens in the partnership stays in the partnership. I mean, it's an incredibly comforting rule to rely on, right? The partnership's debt is its own, and it's not going to follow the partner home. When you have this shield, you can actually operate with a real sense of financial security.
Which brings us to Section 3, the universal agency principle.
But, just when you feel totally safe behind that corporate shield, there's a catch. Universally, across all 3 types of partnerships we talked about, the rule is that all partners are agents of the partnership. What this means is that whatever a partner does directly binds the business, as long as it's in the ordinary course of operations or done with the partnership's blessing. Basically, your partner's actions are the firm's actions.
Now, to really test the boundaries of what actually constitutes partnership business, let's ask a slightly absurd but highly concrete question. What if your partner is out on the weekend and accidentally hits someone with a golf ball, causing a serious injury? Are you, or the partnership, on the hook for those medical bills?
Now, what's really interesting here is the sharp contrast between personal and business capacity. If your partner hits a friend with a golf ball on a random Sunday, well, that's clearly done in their personal capacity. They aren't acting under the instructions of the business, so the partnership is strictly not liable. No way. But let's compare that to a business capacity scenario. Say a partner takes instructions from a firm's client and then maliciously squanders the client's funds. Because that partner is acting as an agent in the ordinary business of, say, a law firm, the firm itself is absolutely liable to pay that debt. The firm pays for business capacity actions, even when those actions are completely negligent or fraudulent.
All right, Section 4. When the shield breaks.
So, we know the firm pays for business actions, right? But what exactly happens when a partner goes completely rogue? Like, does the firm just have to accept bankruptcy? Let's look at a very high-stakes scenario. Imagine your partner, let's call her Rosalia, secretly goes to the bank, takes out a $10 million loan in the name of your LLP, and then squanders all the money. Your firm had absolutely no idea this was happening. Is your firm still forced to pay back the bank simply because she's a partner? So, the crucial point is, to pierce this liability shield and protect the firm, the law uses a very strict 2-prong test from Section 17. For the firm to avoid paying that massive bank loan, it has to prove 2 things at the exact same time. Step 1. The partner lacked the authority to act. So, for example, maybe your internal partnership deed specifically restricted her from borrowing money. Step 2. The third party, in this case the bank, actually knew the partner didn't have that authority. Both prongs of this test literally must be satisfied.
Let's ground this complex legal stuff with a really simple analogy. Imagine a child goes to a local shop and asks for milk and bread on credit. Usually, the shopkeeper just assumes the parent authorized this, gives them the food, and bills the parent, right? the parent pays. However, if the parent had specifically told that shopkeeper in advance, hey, my child has absolutely no authority to buy on credit, and the shopkeeper knew this but gave them the milk anyway, well, the parent doesn't have to pay. This is the concept of constructive notice. If there's no authority, and the third party knew it, the partnership is safe from the debt.
But, wow, here is the massive catch. The burden of proof is heavily on the partnership. Because of something known in law as the indoor management rule, third parties aren't expected to just magically know the contents of your secret internal partnership agreements. The firm can't just run to the court and claim the partner lacked authority. They have to explicitly prove that the bank, or whoever the third party is, had actual knowledge of that internal restriction. And if the firm can't prove the bank knew, yeah, the firm is still on the hook for that $10 million.
Section 5. Dealing with the rogue partner.
So, the good news is you aren't left entirely defenseless here. If the firm is forced to shoulder a massive liability, the law does provide internal mechanisms to recover damages. You can immediately expel the partner based on your deed, or even exercise a lien, basically meaning you seize the money that rogue partner originally invested in the business to cover the losses, and if all else fails, under Section 44, you can apply to the court for formal removal and direct payment orders. Now, there's one last really fascinating nuance to consider here regarding professional undertakings, or PUs, in law firms, because it perfectly summarizes how structure dictates liability. In an ordinary partnership, if an advocate gives a professional undertaking and fails to fulfill it, the individual partners themselves are bound to ensure it gets completed. But in an LLP, because of that separate legal personality shield we talked about earlier, it's the LLP firm itself that is bound. The third party would pursue the enforcement of that undertaking through contractual means against the firm as a separate entity, not the individual partners.
So we've seen that while the LLP provides a fantastic financial shield, the universal agency principle means your partner's actions can still easily bind your firm to ruinous debts. And since your internal partnership deeds don't automatically protect you from third parties unless they explicitly knew about them, it really leaves us with one deeply vital question. Who are you going into business with? Because at the end of the day, trust and character are your ultimate shields. Thanks for joining this explainer, and definitely take a long, hard look at who you're partnering with.